Good afternoon, and welcome to episode number 51 of At Your Service with Haber and Martinez. I'm Haber. That guy is Martinez. How you doing, Ed? Good to see you. Happy Monday.
Good. Can't believe it's 51.
Happy Columbus Day.
Or Indigenous Peoples Day. It all depends.
Well, I'll stick with Columbus if you don't mind.
I'm with you, brother. I'll stick with Columbus.
So today's show, Ed and I decided to entitle Dissecting Two Real-World Current and Local Criminal Cases. And what we did was we took a look in local media and found two local cases that are recent within the last week or so. These are real live cases, real live arrests, and we picked Broward County. And the reason we picked Broward is we want to stay in our general hood. But here in Dade County, we haven't quite hit the 21st century yet when it comes to our wonderful clerk of courts. I love Harvey Rubin. He's a great guy. He's a mensch. You want to go have a drink with somebody at a party? Nobody better to sit and chat with than Harvey. He's just fabulous. And he's a good man, and he's a good clerk. Unfortunately, his office is way behind the times. So every other county in the state of Florida, you can simply go onto the clerk of court's website and click on a link and observe documents. We're not there yet. We're still several years away from that happening here in Miami-Dade County. So in order for us to look at an actual police report here in Dade County, we either have to go stand in line at the courthouse and rot until some deputy clerk calls our number like taking a number at the deli counter at Publix, and then goes and painstakingly pulls the file, and then they charge us $1 a page if we want copies. Or alternatively, we can send an email to a deputy clerk requesting copies and then hope and pray that we get them sometime before we're living in Century Village. Any other county, including Broward, all you have to do is hop on the clerk of court's website. You can print out these documents. So whenever anybody gets arrested and booked into a jail anywhere in the state of Florida, it's a prerequisite that law enforcement submit with the body a written statement of probable cause. Here in Dade County, we'll call them complaint/arrest affidavits. Up in Broward, they call them complaint affidavits or probable cause statements. Either way, it's a sworn statement by the arresting officer as to those facts and circumstances which he or she believes justifies them in having made the particular arrest of a particular individual for particular offense or offenses at a particular date and time within their jurisdiction. So again, we pulled these two cases out of Broward County, and the plan is we're going to talk about them. And we're going to do it with the understanding that all that we know about these cases is that sworn statement from the police, which coincidentally is the starting point for the way that both Ed and I interview clients and anticipate cases and discuss strategies and come up with plans and quote fees. Every case is different. So just by way of example, and I know I'm rambling on, so bear with me for another moment, but by way of example, if both Ed and I get arrested for a DUI, the overwhelming odds are they're not going to be the same exact case based on the same exact facts and circumstances. Maybe I got pulled over for speeding and Ed got pulled over for weaving. Maybe one of us was involved in a traffic accident. Maybe one of us had a suspended driver's license. Maybe one of us has prior DUIs. Maybe one of us had a child or children in the vehicle. Maybe one of us had open containers or controlled substances. Maybe one of us had a warrant. Maybe one of us committed some other violation independent of the alleged DUI. Maybe one of us takes roadsides. Maybe one of us doesn't. Maybe one of us blows or doesn't. Maybe one of us has a double refusal. Maybe there's body-worn camera in one case and there isn't in another. If you get the idea, what I'm saying is if you take a cookie-cutter approach to cases and you simply charge fees based on charges, you're really doing a disservice to you and the client because you don't know what kind of work you're going to have to put into a case. Some cases suck. Some cases, not so much. And I hope to be able to highlight that by going through the two cases that we have today. So what we're going to do is I'm going to actually redo these arrest reports. And then we will discuss them one by one, both from the perspective of how we would view them if somebody came to us for a consultation on these cases. But I want to be very clear. We know nothing about the facts and circumstances of these cases other than what we're reading in the PC. The next logical step from here would be for us to talk to the client. So after we read the PC, we want to then sit down with the client and say, okay, I know what the cops say happened. You tell me what you think. And then we want to follow up with specific questions, because when Ed and I read these, it's going to be through our own individual prisms, right? For 30 plus years, I've been reading these reports. So I hone in on certain things. There's certain buzzwords, certain language, things that I expect to see, things I don't expect to see. They all kind of go into my calculus as to how I'm looking at the case. And Ed, with his 20 plus years of criminal litigation, also as a prosecutor and a defense attorney, does the same thing. You can't just blindly accept the police version of events, even though there's a 99.8% chance that that's exactly what the prosecutor is going to do. They're going to look at this report. They're going to believe every word in it as if it was walked down from Mount Sinai, in tablets scribbled by the hand of God being held by Moses. Most of the time, they're just not going to question it. They're going to, especially on your lower level cases, right? So if it's county court, if it's a misdemeanor, if it's a DUI, the overwhelming odds are there's never going to be any second guessing. I mean, obviously, when you get more sophisticated and you get into major crimes and specialty divisions, that's a different story.
I don't want to take your thunder, but it's not just that, Michael. It really goes into the amount of experience you have. That's really, when you start off at the state attorney's office, you start off on the low level crimes and you don't have enough experience reading them. For example, in the 30 years you've been practicing, I have probably tripled the amount of A forms I've read that you have, because I've read hundreds and hundreds and hundreds and hundreds of them as a prosecutor. So when you first start off, you start reading, you don't really know. You don't have much experience. But as you get more experience and you get into the upper level crimes, now you have more experience.
So
now you read these A forms and you go, wait a minute, that doesn't sound right. That's weird.
Neither of the cases that we're talking about today are in that level. These are all, they're both serious. And any criminal charge, I don't care what it is, they're all serious because they all have serious consequences. Yes. Including collateral consequences, which are very important. And these are part of the things that Ed and I would consider when we talk to the client after we've read this report. What is that individual's unique circumstances? What are the things that we need to worry about with them? Are there employment issues, family issues, licensing issues? All of these types of collateral things that we know through our experience that can be, extremely significant, perhaps even more significant than the criminal case itself in some circumstances. So with that background, I'm gonna go ahead and as I said, I just want to remind you all, while these are real live pending cases, they have not yet been arraigned. We have never spoken to either defendant or their lawyers. I did not read any news articles about these cases other than to use a Google search to find the fact that they existed. I didn't even read those because I didn't even want to be poisoned by anything the media said. So all we are operating on right now is the blind statement of probable cause by law enforcement. Capiche? Ed, are we good? All right. With that, let's do our first one. The charges in this case, I will give you those up front, if I can find them. What did I do with them? Oh, here it is. This individual was booked into the Broward County Jail on October 2nd on one count of possession of cocaine, third-degree felony, and one count of use of a firearm under the influence of alcohol / firing a weapon or discharging a firearm in public, which is a misdemeanor. Here is the sworn statement of probable cause. After we go through the statement, after I read it to you, Ed and I will go back and we'll spend some time kind of dissecting it. Okay? Ready? Here we go. The defendant did unlawfully discharge a firearm outdoors on property used primarily as the site of a dwelling and was in constructive possession of cocaine, to wit. On October 1st at approximately 9:06 p.m., I was dispatched to a residence in the city of Sunrise, County of Broward, state of Florida, in reference to the complainant stating that she had had a verbal altercation with her husband, the defendant, and that her husband discharged a firearm into the air. The incident location is a residential dwelling. Upon arrival at the nearby staging location, located approximately 570 feet from the incident location, myself and other Sunrise police officers heard the distinct sound of a single gunshot come from the incident location. While other officers maintained a visual of the incident location, I responded to a 7-Eleven gas station located down the road, where I made contact with the complainant. The complainant stated she resides at the incident location with her husband, the defendant, along with their 2 minor children. She stated that the defendant arrived home at approximately 9:00 p.m., apparently intoxicated by alcohol, at which time she confronted him about suspected infidelity. She stated that a verbal altercation ensued, during which time the defendant repeatedly loaded and unloaded multiple firearms as they argued. She stated that although the altercation never became physical and that no threats were ever made with the firearms, she felt uncomfortable and decided to leave the residence with their 2 children. She stated that as she walked to her vehicle, the defendant was already outside. He asked where she was going with the kids. She stated she told him that she was going to a friend's house and that she would return later that evening. She stated the defendant then kissed both of his children goodbye, at which time she began to drive away from the residence. She stated that while she was driving away, she heard 1 or 2 gunshots come from the incident location. I asked if the defendant had fired at her vehicle, to which she replied no. She stated the defendant would never do anything to harm either her or their children, and she was adamant that he did not fire at her vehicle. A visual inspection of the vehicle showed no signs of damage or any bullet holes, and neither of her children had any marks or bruises visible on their persons. While speaking at the 7-Eleven, we established phone contact with the defendant and informed him that he needed to exit his residence to speak with officers who were on scene at the incident location. A short time later, it was advised over the radio that the defendant was safely detained pending further investigation. Once the defendant was detained, a protective sweep of the residence was conducted for possible gunshot victims, yielding negative results for any other persons inside. The garage of the residence is connected to and part of the residence, with a door leaning from the garage into the interior of the residence. During the protective sweep of the garage and residence, a black semi-automatic pistol and a black semi-automatic rifle were observed in plain view on a workbench inside of the garage, while a third semi-automatic pistol was observed in plain view inside of the residence. Additionally, a clear plastic bag of white powder was observed in plain view on the floor of the garage, directly in front of the workbench where the 2 firearms were located. The victim signed a Sunrise police consent to enter and search form, not the defendant, the wife, authorizing officers to search the residence for additional firearms, ammunition, or contraband. I responded back to the incident location, where I was advised by officers who had remained on scene after I went to meet with the complainant that they had heard a second gunshot come from the incident location while I was gone. A search of the front yard revealed multiple shell casings and divots in the ground consistent with bullet impact marks. It should be noted that officers did not observe anyone other than the defendant entering or exiting the garage or residence, during which time the defendant had actual physical control of the immediate area where the 2 firearms and the bag of white powder were located inside the garage. The bag of white powder weighed approximately 0.026 grams with packaging, and the white powder field tested positive for cocaine using a department-issued cocaine testing kit. After confirming the presence of cocaine, I asked the victim if she knew her husband to use narcotics, to which she replied no. I then asked her if the baggie of cocaine belonged to her. She again replied no. Based upon her allegations, multiple officers' audible observations, and physical evidence on scene, the defendant was taken into custody for recklessly or negligently discharging a firearm outdoors on property used primarily as the site of a dwelling, and for possession of cocaine. The defendant was transported to the Sunrise Police Department for completion of this probable cause affidavit before being transported to the Broward County Jail. And there you have the story of this individual.
You want me to tell you what I think is going to be their first problem?
Yes, go ahead.
First problem is, correct me if I'm wrong, they did in fact charge him with discharge, improper discharge of a firearm, which is a misdemeanor. Right?
Well, it's curious because I'm looking at 2 different documents. On the arrest report, on the complaint affidavit, what the officer wrote in here, what they charged him with and booked him into the jail for, is firing a weapon, discharge firearm in public.
Right.
When you look at the booking report, which is a document created by the jail, this is what the jail booked him in under. they booked him in under use of a firearm under the influence of alcohol.
Right.
So I don't know where the disconnect is there, but that's something the state attorney's office is going to have to figure out during the pre-file period when they decide whether or not they're going to charge him with either of these offenses, both of these offenses, or some other offense.
Before we get to the cocaine, so but either way, both of those offenses are misdemeanors, and none of them are on the exception list. I'm 90% sure they're not on the exception list of misdemeanors. Officers can only make an arrest of a misdemeanor if it occurs in their presence, unless it's one of the exceptions, domestic violence.
Well, but they have another exception here because they arrested him on the misdemeanor incident to a felony arrest. So it's 6 of one, half a dozen of another.
But they still didn't observe it. Look, at the end of the day, they're going to have a difficult time with that charge, Michael, because they didn't observe it from the A form unless they put it in what's. And just so we're clear, guys, short term for the probable cause affidavit is an A form, affidavit form. So you'll hear Michael and I talk about it as an A form or something. At least I do. Then they have the offense incident report, which we call the OIR. Unless they put it somewhere where they did gunshot residue, I don't see how they're going to get that charge. Any prosecutor worth his salt would just not file those charges.
Let's talk about what they did do. So it's interesting how they claim. Let me go back to this PC real quick. In regards to the firearm, there's several things in here that I find curious. Okay. One, it's interesting that they set up a staging location. Now, they did that because they know there's a firearm involved. The 911 call said that there was a shot fired. So these cops are not going to physically roll up on the scene when they know the victim is off scene. Now, what they don't know is whether anyone else is in the house or whether or not he has made himself a hostage, right? Sometimes that'll happen where somebody says, don't, like the old Blazing Saddles, anyone makes a move and I get it, right?
Yeah. No, you laugh. But guys do that in cops.
Right, so you don't know. They don't know, so they stage, a little ways away. Now, the officer who writes this form indicates that while they are staged, right? Because he says, myself and other officers heard the distinct sound of a gunshot. So he claims that he hears that and other officers hear that, which is a little bit inconsistent with what he says later in the report, where he talks about how he's already at the 7-Eleven meeting with the complainant, the wife, when officers on scene hear gunshots. Well, now, it may be that they were two separate incidents. I don't know. It's unclear from reading this, right. But there's at least some question as to whether or not he's claiming that he was present for something that he wasn't present for.
And just
either way, hang on. Before you go there, either way, I just want to mention one thing. It doesn't matter at the end of the day, because there's a thing called the fellow officer rule. And the fellow officer rule allows the cop who makes the arrest to rely on what he's told by other officers as opposed to having observed it himself.
Right. And we're jumping around a little bit here, like we talked about prosecutors earlier in your monologue. Let's be crystal clear. Right now, we're focused on the probable cause. And remember, probable cause is a much lower standard, and that's the officer's standard. So a lot of this stuff may actually be legit to make the arrest, and that's what we're dealing with. Is it enough to make the arrest? And some of the stuff, Michael and I will agree that it's enough to make the arrest, but not necessarily enough for the state attorney to charge. Or be able to
let me just throw this in there, okay? If this arrest occurred, and Ed and I were contacted and asked to show up at the bond hearing, we would be arguing about probable cause.
Correct.
Okay? But the bond hearing is already over. So that's not even an issue anymore. The judge has already determined probable cause. Now the question is there something that we can find based on our review of this document, our interview of the client, and our knowledge of the law, and whatever research we may or may not have to do in this particular case, to go to the state attorney and try and convince them that even though the arrest happened, they should not file X, Y, or Z, right, or they should file something different, or what have you. And then if that fails, then we go into the defense perspective. But with regards to that gunshot, so we have another very interesting thing here, because he's got this one paragraph they put in at the end. It should be noted, officers did not observe, blah, 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 and they talk about the front yard revealed multiple shell casings and divots. Okay, well, here's what we don't know. We don't know whether any of these officers are wearing body cameras, so we don't know if there's any visual observation that can be made by a prosecutor, a defense attorney, a judge, or a jury. If there is, that's one thing. If there isn't, that's something entirely different. We don't know whether or not crime scene was ever called. We don't know if any photographs were ever taken of any of these things. So we don't know whether or not we have to rely upon simply the words of this officer in this document, or if there's physical evidence that corroborates it. And if there's corroborating evidence, then the case gets an awful lot harder, because obviously it's going to be more difficult to argue that there were no bullet holes in the ground, or divots as they call them, or shell casings laying in the area. We also don't know if they impounded the weapons. Presumably they did, but they don't tell us that in this police report. We don't know whether or not they conducted a gunshot residue or a GSR test on this individual, which would be very good police work, right? If you want to prove that this guy discharged the gun, how do we know who discharged it? The wife never says that she saw him do it, nor does anybody else. Everybody hears gunshots. How do we know it was him? How do we know there wasn't somebody else in the house? How do we know it wasn't his fairy godmother? How do we know it didn't discharge itself? We don't know any of these things.
Right. So the first evidence that they need to get is, and I'm assuming they didn't put it in the A form because they probably called crime scene. We don't know because we weren't there. But with my years of experience, if the officer had done what I'm about to tell you, he would have put it in the A form. But he also could have chosen to say, look, don't touch anything and let's call crime scene. So you found shell casings. What is the caliber of the shell casings? And what are the caliber of the firearms you found in the house?
Exactly.
Because if you 45 caliber shell casings, but you don't find any 45 caliber handguns, there goes their case, right? Because they're blind.
And even if they did find matching shell casings to caliber, without a ballistics exam, we have no idea whether they were fired from that gun.
Right, but so that's right. So let's say you did find this. Okay, well, it's a little bit better because you show 45 caliber casings. He's got a 45 caliber handgun. Okay. Was the handgun recently fired?
We don't know.
They can tell easily. The GSR, the gunshot residue, if it's on his hand, he certainly fired a handgun. Now, you wouldn't know if it was a 45, but you know he
fired a gun.
And then if you got a 45 caliber that has been recently fired, and you got 45 now the case starts getting much stronger for the state. But that's why you hired Mike, for us to go in and point out all the deficiencies where it really should have been easily done.
So let's talk a little bit about the cocaine now. On the cocaine component, so first off, I want to mention one thing. The reason that they find the cocaine is because after he was taken into custody, quote, a protective sweep of the residence was conducted. What is a protective sweep? A protective sweep is basically a search. It's a cursory search. They're not opening drawers or anything like that, but they are entering the property without a warrant under the premise that they have to make sure that there's no other threat or nobody that needs medical assistance or attention on the premises. They know that there's guns. They know that there's guns fired. They want to be sure that there's nobody else. So what if somebody's bleeding out in the bathroom? There's no way for them to know it. That's what the protective sweep is. It's simply a cursory inspection. But like any other instance, if a law officer is legitimately in a place and while legitimately in that place observes contraband in plain view, then that contraband is not subject to a warrant. It is impoundable under the plain view exception to the warrant requirement. So the cocaine is discovered at that point. Now, where the cocaine is not, it is not on his person. So there is some argument as to whether or not it's his cocaine. Now, you notice that the police officer goes to great lengths to document and cover his decision to make the arrest by saying...
My assessment is that this cop knows that the case is weak, but he knows the law. He knows what he's doing, and he's a good cop. And he's just making sure he puts every piece of information that went through his noggin as he was deciding to make this arrest, because they're going to argue.
I'm going to tell you why he did that in a minute.
They're going to argue totality.
I'm going to tell you why he did that in a minute, and there's a damn good reason for it. You wouldn't know it from reading this police report. After confirming the presence of cocaine, I asked if she knew her husband to use narcotics. She replied no. I asked if she used narcotics. She said no. So this guy is covering every base, like you said. This isn't actually, if you were teaching a class on how to write an arrest report, this would be a pretty good arrest report to use as an example.
I did. I trained in the academy for that. My only complaint is he could have made it a little more concise, but it's very well written.
It's detailed. It's maybe a little superfluous, but here's why. This is what you don't know. And it's a critical fact that I guarantee you these Sunrise police officers were thinking about when they wrote this arrest report. The defendant is a Miami-Dade police officer. The man they arrested is a cop. So they are taking no chances. They are dotting every I and crossing every T in order to. So they know that the allegation alone means this guy is going to be suspended from work, possibly without pay, maybe with or without. I don't know. That's, department protocol. But either way, he's suspended. He is definitely off duty. He's definitely not going to be touching any firearms or carrying any firearms. And he's going to be subject to interagency scrutiny just because of these allegations. And that's one of those things that Ed and I talk about as being a collateral consequence. If I were arrested for this, it would be different. My Florida bar license would be at stake, right? If some college kid were arrested for this, their status in university might be at stake. So maybe somebody who has absolutely no professional licensing or no job or no whatever would have none of those collateral consequences, but other people do. So in part of the evaluative process, when we sit down with the client and talk to him about this case, one of the first questions is going to be, what do you do for a living? Do you have any licenses? Do you have any loans? Do you have any academic pursuits? Is there anything we need to know about you? Do you suffer from any mental illness? Are you going through any tragedies? Have you been diagnosed with PTSD? Maybe there are explanations for some of these things. Maybe there's a nanny in the house. Maybe one of their kids is a teenager. Who knows? The cocaine could have come from anywhere. And here's another thing. Just one more thing off the top of my head with regard to the cocaine.
Go.
Do we know? We don't know. But did these officers take that cocaine bag and send it to the crime lab and try and have it fingerprinted? Who touched that bag of cocaine? Because again, just like gunshot residue, if our client's fingerprint is on that bag, well, you know what? He's pretty much toast. But let's say it ain't his fingerprint. Let's say somebody else's fingerprint is on that bag. That exonerates him.
Well, there's two things that could exonerate him. But going back to the first thing you said, obviously, one of the very first questions we're going to ask is, where did cocaine come from? Because our clients, some of our clients are honest, and he may say, yeah, man, it was my coke. Okay, we're done. When did you last snort? I snorted about 3 hours before the cops came to arrest me. We're done. And the beauty of our criminal justice system is that our clients don't have to prove anything. And I really do mean that. It's really the beauty of the system because, as Ben Franklin said, it's better 100 guilty men go free than one innocent man be convicted. So it's really the onus has to be on the state. And why is it beautiful? Because like Michael just said, there's things the state can do. They can fingerprint the bag. Now, I can tell you my experience from fingerprint techs. They will all tell you that finding fingerprints on a plastic bag is very, very, very rare. It's possible, but very rare. But I'll tell you what is on the bag. DNA. No doubt there'll be DNA on that bag. However, once again, because DNA testing is very expensive, this is a case that probably would not qualify for DNA testing. So it would either have to.
But that's right for defense attorneys. That's where we get to go absolutely tee off on the state because they don't do it in cases like this.
I had a case years ago. One of my very first cases as a prosecutor. I called the crime scene tech, and I said, "Did you test for fingerprints and DNA?" And he told me no. And exactly, and this is why I know it was plastic bags. And he said, "Hey, it's plastic bags of heroin. You're not going to find it." I said, "I don't care, but I need you to come into court and testify that you did in fact look for it and you didn't find it." Because I knew a good defense attorney is going to argue there's no fingerprints, there's no DNA. They didn't even care to look. So it's what we'll do. A good defense attorney will bring it up. And why? Because look, I was a young prosecutor, Mike. All it took was for me to make a phone call and say, "I don't care. I want you to do it." And they did it. It was that simple.
Let me get out a couple more thoughts on this.
So that's the first question is, Where did it come from? Now, let's say our client said, no, I'm telling you, man, it's not my coke. Well, something we have in our arsenal. Well, now we turn on to the defense, the offense. Now we'll turn on to the offensive. Is they'll say, okay, let's submit you to a hair sample and show that to the prosecutor and be like, listen, here's a hair sample. Guy's got long hair. He didn't have any coke in his system. So you're not going to get a cocaine conviction. It's very possible that it was the wife's coke because she would have motivation to lie about that if it was hers. So
Let me hit a couple more observations because I want to get to our next case.
yeah, I got that.
Couple more observations I have on this. So, when the officer interviews the wife at the gas station and asks her what happened, and she says, my husband came home, he was intoxicated, and I confronted him about suspected infidelity. Maybe not the best decision by her, okay? If your husband is a gun-toting, intoxicated person, you probably don't want to challenge him in that moment about affairs. Maybe wait until morning, right?
It's an emotionally charged issue, my friend.
I got it. I'm just saying it's an observation.
I agree with you. But I also
the other, some more observations are, how do we know he was intoxicated? If they charged him, remember, they didn't charge him with this in the A form. In the A form, they charged him with discharging the firearm in public. But in the jail, they've got him booked in under use of a firearm while under the influence. How do we know that? Just because she said so? Did anybody give him a blood alcohol test? Did he blow into a breathalyzer? How are they going to prove intoxication or impairment without any of that?
They can't. They're not going to. The officer didn't even.
Another thought.
That he smelled an odor of alcohol in his breath. They had bloodshot, watery eyes. That he was
none of that is in here. We don't.
In this case, it's improper display of a firearm in public. And again, honestly, Michael, I don't know
how they're going to prove that he did it without GSR and without a physical witness.
Yeah, they're going to have
to. So we got GSR, ballistic statements. I don't know if any statements were made by him. They say absolutely nothing about him. Did he engage? Did he invoke? What did he do? I mean, he's a cop. He's probably smart enough to invoke, but not necessarily.
I don't know. I've represented several cops, and every single one of them opened their mouth way too much.
And I've represented several cops who have buttoned up and said absolutely nothing. I want my lawyer. So there's, again, we don't know. It's one of those things that you don't know from reading this document.
I've got police who just keep confessing when they get arrested.
And then the last thing I want to mention here is that it's very important that there was no domestic violence here. He wasn't charged with domestic violence, and the wife was very clear that he didn't commit any act of domestic violence, and he didn't threaten her. So it's curious, and whether or not how the state is going to play with that. Obviously, they'll argue, well, it's admissible because it's inexplicably intertwined, and there's no other way for us to explain why the police were there if we don't do this, and here's the 911 call, and it's an excited utterance, and blah, blah, blah. They'll try their best to get that in, but as defense lawyers, we would argue that it's completely prejudicial to make any statement about domestic violence or domestic arguments or domestic disputes in a case that is not domestic.
Well, but also if it comes in, we can also turn this particular one into a sword for us because she clearly states he didn't commit any domestic violence, and that he's not abusive, and she never thought. So then the question begs is, then why the hell would he just randomly shoot guns into the ground like an idiot?
And she makes a statement that, quote, or something along the lines of, he would never hurt his kids or me.
Correct.
So, all right, let's get on to case number 2. Good discussion on case number 1.
Just as you're going on, that's kind of what goes through our thoughts as we're looking at just the arrest affidavit. Even the things that aren't answered, like we've said many times on this show, a good defense lawyer, any good trial lawyer is like playing chess. He's 20 steps ahead. So Michael and I go through this and we anticipate possibilities like a chess game, possible moves. I don't know. Is there a statement? Is there not? Did they do JSR? They just didn't put it. We've got to anticipate every possible move on the chessboard, even though we're given just a limited amount of info.
So what you got is a little preview of how we look at this, our prism of how we look at this. And these things that we're talking about right now with you guys and amongst ourselves are the questions we would be asking the client. Did they do gunshot residue? All of these types of things, because we don't know. Did you make any statements? Did you say anything? This guy may have adamantly denied it. Perhaps he said, no, we have my 15-year-old kid has the friends in the house and they were in the garage playing video games. I don't know. I don't know what that garage looks like. Anyhow, let's get on to our next case. Our next case, our individual was booked into the jail on October 1st on 5 counts. Well, 4 counts, one is a traffic infraction. He was booked in for DUI, first offense, DUI over, meaning DUI with a breath above 0.15, 2 separate counts of bribery of a public servant, and an infraction for driving on the wrong lane of traffic. And with that background, I will now read you the arrest report. On September 30th at approximately 11 p.m., Deputy Simmons was operating a stationary radar on Nob Hill Road in Parkland, Florida, when he observed a white Range Rover traveling southbound in the northbound lane of traffic. Deputy Simmons was able to conduct a traffic stop on the Range Rover as it came to a stop at a red light at the intersection on Heron Bay Boulevard North. It should be noted that there were northbound vehicles that were stopped at that intersection. Deputy Simmons made contact with the driver, who identified himself with his Florida driver's license after fumbling briefly through his wallet for identification. Deputy Simmons observed the defendant to be disoriented and confused. The defendant was unable to advise where he was coming from or where he was going to. He had difficulty looking for his keys, which turned out to be a fob. He exited his vehicle apparently to look for his keys and was unsteady on his feet. During conversation, Deputy Simmons detected an odor of alcoholic beverage emanating from the defendant's breath. 2 styrofoam cups with an unknown clear liquid were observed in the center console cup holders. I was contacted at 11:04 and asked to respond to conduct a DUI investigation. I arrived on scene at 11:29. I was informed of the aforementioned by Deputy Simmons. I contacted the defendant, who was still seated in the driver's seat and was being monitored by Deputy Hanchard. I introduced myself and made initial observations of the defendant's glassy and bloodshot eyes. During a brief conversation, I detected an odor of alcoholic beverages emanating from the defendant's breath. I informed him that based on Deputy Simmons' assessment and of my own observations, I was going to initiate a DUI investigation. I requested that he walk to the front of my patrol vehicle where roadside sobriety exercises could be performed. The defendant stated, quote, "I understand," and made no objection to exiting his vehicle and walking with me to the front of my patrol vehicle. He had difficulty walking straight as he staggered about. I noticed a small cut on the right side of his temple. He stated that he got it from the car. As I tried to look at it, he kept turning around with me. He stated he was not diabetic, he was not taking any medication, he did not have any injuries, illnesses, or any balance issues, he did not wear contact lenses or glasses, and he was feeling healthy. He was unsteady on his feet, he swayed from side to side, he rocked back and forth while trying to stand still in front of me. The following exercise were individually explained and demonstrated prior to the start of each exercise, and the exercises were conducted and performed in the street. Horizontal gaze nystagmus, the defendant had difficulty standing still as he continually rocked and swayed. At one point, he fell forward into me, and he had to hold on to me to maintain his balance. He had equal tracking, equal pupil size, and no resting nystagmus in both eyes. He continually moved his head with the stimulus, and he had to be reminded to keep his head still. He also kept looking forward, failing to maintain concentration on the stimulus. He displayed a lack of smooth pursuit in both eyes, a distinct and sustained nystagmus at maximum deviation, and an onset of nystagmus prior to 45 degrees in both eyes. There was nystagmus observed during the vertical nystagmus check. Walk and turn. The defendant failed to keep his balance while listening to the instructions. He kept stepping off the line. He walked forward 15 steps instead of 10. He continually stepped off the line and missed heel to toe throughout the exercise. He stopped before the turn. He had to be reminded to walk back the other way. His turn was performed not as instructed, and he walked back 14 instead of 10 steps. He missed heel to toe, and he stepped off the line throughout on the return. He did not count any of his steps out loud. One leg stand. The defendant swayed from side to side while balancing. He bent his knee. He placed his foot down multiple times. He held his arms outward to assist with balance. He stopped the exercise before being advised to do so, and he did not count out loud as instructed. I placed the defendant under arrest at 11:55 and requested a breath test, to which he replied that he would. While on scene, I was advised by Sergeant Hernandez that Mullen had bribed Deputy Hanchard and Deputy Guerrero to make this incident, quote, go away prior to my arrival. I spoke with Deputy Hanchard, who stated that while she was monitoring Mullen, he pulled two $100 bills from his wallet and he tried to hand them to her. When she asked what the money was for, the defendant told her, just take it. When the Deputy Hanchard denied it, the defendant asked for another deputy, motioning for Deputy Guerrero to walk over. I was advised by Deputy Guerrero that the defendant tried to hand him a wad of cash, appearing to be several ones and fives, which he refused to take. While on scene, I checked the two styrofoam cups. The liquid had a tequila odor to it. Digital photographs of the cups were taken and uploaded to evidence.com. Money totaling $322 in United States currency on the center console was entered into evidence. The vehicle was towed from the scene. Deputy Simmons transported the defendant to BSO testing facility with arrival time of 12:38. BAT Tillman conducted the 20-minute observation, and then the defendant provided valid breath samples of .195 and 196 at 107 and 110 hours, respectively. The defendant was read Miranda per form, and he stated that he understood and would answer questions. He stated, I had 1 to 2 margaritas at Legends. He believed he was not impaired. He was safe to drive. I asked him about the bribery. He denied that it occurred. Deputy Simmons completed a DUI supplemental report. The defendant was transported to the main jail, BWC, and patrol vehicle dash cam.
All right.
Okay, a lot to unpack there.
Can I just start with one thing that we need to keep in mind in the backdrop? As we're looking at this, at least when I do these, is one of the biggest hurdles he's going to have with the DUI is breath. He blew twice the legal limit. So
2.5.
Huh? Right. So at this point, we're looking at having to either have an expert challenge the equipment to test it and see if it was accurate or not. But that's something that, at least when I go through these, is in the backdrop, that no matter how many holes we poke in this, there's still a breath reading of over twice the legal limit. That's going to be a hard hurdle to get over with respect to the DUI, without even touching the bribery issue. That's something that needs to be considered.
Okay.
What do you want to?
Well, I will tell you. Well, just on that token, we're not supposed to tell you what to do or not to do. Everybody's got their own decision to make. But I will tell you right now that a DUI defense attorney's best friend is a double refusal. No roadsides, no breath. And with this, I've got some things I want to point out on that. But let's start with this premise. In Florida, there's a law called implied consent. Anybody who accepts a driver's license in the state of Florida, by virtue of accepting that license, agrees to take a test if requested to do so by law enforcement. That is your contractual obligation. You do not have a right to that driver's license. It is a privilege granted to you by the state, and it is a conditional privilege. The condition being, if a cop asks you to blow, you blow. That said, you have the right to refuse. They cannot compel you to blow. They can't hold a bag over your head until you have to take a breath and then stick the thing in your mouth. So, I suppose they could, but it wouldn't be admissible. So you have a right to refuse, and Florida has what's called an implied consent law. So it's an actual physical form. If that form doesn't exist, no breath reading is coming in. They must read you implied consent, and you must sign off on that form before you can give a valid breath sample. And implied consent basically says, we're asking you to blow. You don't have to blow if you don't want to blow. If you don't want to blow, you're going to automatically get a driver's license suspension. And if you had a previous suspension, it's going to be even uglier. And you could be accused of, you will commit a second independent crime. But that said, it's your choice. We can't force you to do it. And they have to unequivocally read you this law, not only verbally, but they got to give you the piece of paper, whether it's in English, Spanish, or Creole. And you damn well have to sign off on that thing, because if there's no signature on that, they're going to have a very hard time getting that breath reading into evidence. It is an absolute prerequisite. Now, consider that in light of roadside sobriety examinations, or FSTs, field tests. No, there is no such implied consent rule for that. You don't have to take them. There is no requirement that you take them, and your license will not be suspended if you refuse to take them. But the cops don't have to tell you any of that, and they almost never do. Some do. Smart ones do. Because if you do, in fact, take the test, then they want to be able to let the jury know, look, I told him he didn't have to do it. He chose to do it. Because that's even more proof of your voluntary nature, right? But when they don't tell you, and in this case, look at the language this officer used when he talks about roadsides. I informed that I was initiating a DUI investigation. I requested he walk to the front of my patrol vehicle where roadside sobriety exercises could be performed. He stated, I understand, and made no objection. He wasn't told he could object.
Right.
He wasn't told. He was told, I want you to come to the front of my car to take these tests, which if you are, I don't care if you're drunk or you're sober, unless you are a professional citation driver or criminal, most people get nervous when they're confronted by police officers, when they are stopped by cops. That is exponentially worse when it's done at nighttime, and it's even more complicated when you know that you're being investigated for a criminal act. So the coercive nature, the environment itself, is not conducive to anybody saying, no, thank you, officer. I think I'm good where I am. I'm just going to stay right here in my car. No, he was basically coerced to do it. And again, it's not illegal. They don't have to tell you, as they do with breath. So everybody should know that regardless of this particular case, that's just a little pet peeve with DUIs. There is absolutely no obligation for anybody to take roadside sobriety examinations. You're perfectly free to do it, but you do so at your own peril, kind of like swimming at an unmanned beach during a rip current.
Right. And with regards to the implied consent, yes, if you don't blow, your license will be suspended. Same with the horizontal gaze nystagmus. That's a separate crime for refusing the HGN. But if you do and you are impaired, as this gentleman is, really a moot point because he got arrested anyway, and his license is going to be suspended because that's administrative.
Well, he did get arrested anyhow, but he armed the government with an awful lot of evidence in this case.
Correct.
So let's go through a few of these things. First off, this is a clean stop. In any case involving an automobile, the first thing that we're going to look for is whether or not there's any potential to file a motion to suppress based on a bad stop. When you're driving southbound in the northbound lane of traffic, that's as clean a traffic stop as you're ever going to get in your life. So that issue is out. Next, let's talk about, now we don't know what Deputy Simmons actually saw. Again, there's another example of the fellow officer rule, right? Because the officer who wrote this A form is telling you what he or she was advised by the other officer. But let's just assume for a moment it's true. Two things on that. First off, the last thing I read in this A form was BWC and patrol vehicle dash cams. That means this is on body worn. So as a defense lawyer, when we read this, we say, okay, every single word that we just read in here, including, let's go to the minutia, 15 steps forward and 14 steps back. That video damn well better show that. Because if it shows anything other than that, we now have an officer who made an inaccurate statement under oath in the police report, which at least gives us the ability to argue if he did it there, he did it elsewhere.
Exactly.
So body-worn camera is both good and bad. It's good in that it really does simplify things, right? Because we could argue until we're blue in the face, like on our first case. We don't know. What if they didn't preserve that crime scene? What if there was no body-worn? What if nobody took pictures? Do we know that those divots actually existed? The fact that they may have shell casings in evidence, do we know that they came from that particular location? I mean, we don't know. We have to accept the officer's veracity that they're telling us the truth. But with body worn, if they're physically picking up those things while it's on body worn, or even if they have crime scene come and take photographs so that you can see the overall area, the individual close-ups, everything else, it leaves less room. And that's what we have here, right? But you have these little individual behaviors that are the kiss of death in DUI cases. And that's why we expect to see them in these police reports. If the body worn, again, corroborates them, it's going to be a very difficult road for this defendant or for any defendant. So, for example, let me just give you one quick example. When the officers first gets him out of the vehicle, and he's standing there, and he's instructing him on the HGN test, and he says, quote, "The defendant had difficulty standing still as he continually rocked and swayed. At one point, he fell forward into me and had to hold on to me to maintain balance." Again, if the video shows that, it's going to be very, very damning for the defendant. Not only is it in line with what the officer has proffered, but try and explain away how or why that happens when you're having a conversation with somebody, looking them in the face, and you just fall forward into them during that conversation. Not a good visual.
Yeah,
but
and the explanation we're looking for is not I had too many margaritas.
Right. Only two. No, I had one or two. That was it. By the way, better to say nothing.
Yeah.
You don't need to tell them how many margaritas you had.
That's actually a running joke in the office. Whenever we would read A forms on DUIs when we started, and we always laugh. Everybody always says I had one glass of wine, I had one beer, two beers. Everybody always says.
Meantime, he blew a 195, 196.
Always.
So
don't even bother.
Look at these little cues, right? Fumbling briefly through his wallet for ID. Why do they put that there?
They're trying to show he's impaired.
Couldn't advise where he was coming from or going to. Well, I don't know if Deputy Simmons was wearing body cam, but I'd certainly like to know, because I want to know if what Deputy Simmons told the arresting officer actually happened. Right. Deputy Simmons doesn't have body cam. We don't know that it happened. We have to rely on the arresting officer's statement. And, probably Deputy Simmons would be called as well to come in and say, yes, this is what the defendant said to me. Defendant was looking for his keys, which was a key fob. Did he say, "I'm looking for my keys. I can't find my keys. Where are my keys?" And it turns out to be a fob? We don't know.
That's even irrelevant, because I call my key fob keys. Everybody calls their keys keys.
Defendant was unsteady on his feet. All right, odor of alcoholic beverage. I got a couple issues with this. You almost never see a DUI arrest report that doesn't have that. Every now and then you do, because DUI can also be controlled substances. It doesn't have to be alcohol. And other people don't have an odor of alcohol. Some people brush their teeth, or some people sufficiently attenuated, or use mouthwash, or eat breath mints, or just have really, really bad breath, halitosis. When an officer says they detect an odor of alcoholic beverage, what they are taught in the police academy, and what they are taught in subsequent training to be certified as DUI technicians, is that you cannot isolate the type of alcohol, only that there is an odor of an alcoholic beverage. You almost never read, "I smelled vodka on the defendant's breath. I smelled tequila on the defendant's breath. I smelled wine." No, it's always an unknown alcoholic beverage, except for this particular officer, who apparently loves his tequila, because when he checked the styrofoam cups, quote, "the liquid had a tequila odor to them." To me, that's great fodder for cross-examination. Now, again, it's not going to much matter in a case where a guy blows 0.195, 196, is traveling the wrong way on Nob Hill Road. These things don't work. But if you don't have those things, if you don't have them, that's a really good area for us to be able to attack the officer as to his ability to do that. But I do have some other questions about that, right? So he's wearing body cam. We should be able to see them. He says that he checked them. Well, did he impound them? Did he take them into evidence? Did he send them off to the crime lab to be tested? Guy wasn't charged with an open container violation. Why not? Is it an open container? Is it not an open container? Is it alcohol? Is it not alcohol? Again, with a 0.195, 196, the minutia, is generally going to be irrelevant, but we still need to consider things, because even the littlest of things can blow up a case.
But it's a good case to show how simply doing the breath eliminates all these possible arguments. If this individual had refused the breath, all of these arguments are in play. But the minute he does the breath test, now the only argument is going to be an expert, which is going to cost a lot of money, to come in and check out the breathalyzer and make sure that it was correct and it was reading correctly and all that. And normally they are, to be honest. Hardly ever are they not checked and inspected. And what's the word I'm looking for, Mike? When they update them, when they check them out and they go through their testing to make sure the equipment is functioning.
Inspections. They do monthly, they do semi-annual, and they do annual.
Well, normally they are. So all these, like I said at the beginning, that's why I mentioned in the beginning, keep in mind that there's that 0.19 out there that makes all these arguments much more, or makes it less relevant.
So all these little things add up. The minutia adds up. But here you've got some really, really bad facts. Again, the driving pattern is horrible. The breath reading is the kiss of death. And if you have that body worn that matches up even just substantially with the allegations of swaying and inability to balance and completely blowing all three of those roadside examinations that he was given, this case is pretty much a foregone conclusion. The only issue that we have here, and I want to bring up 2 points. Cops love to do this, okay? I don't know if they do it because of crime statistics or if they do it because they don't know any better or because they're trained to do it this way or what. You can only be convicted of one DUI for one incident. Yet they gave this guy 2 DUI tickets.
I'll tell you why.
Why?
I'll tell you why they do it. Because they're trying to bump up the bond, just in case he tries to bond out before he appears before the judge. He'll pay a much higher bond.
It's not that much more. It's a misdemeanor. It's not that much more on the bond. That may be part of it. That could be the reason. But my point is, it's a pet peeve to me, and I want you all to know that if you do get a DUI and they cite you for DUI, DUI over, DUI accident, you can only be convicted of one of those DUIs. You're going to be, you could be convicted of multiple things, but you can only be punished for one of them. Otherwise, the violation of double jeopardy. So that's one thing I want to point out. The other thing I want to point out here is I want to talk a little bit, because we only have a couple minutes left, the bribery issue. All right, because that's a biggie. Because right now, but for that bribery, with all of this stuff that we read, with all these horrible facts, it's still a misdemeanor. Worst case scenario, it's a first-time DUI, it's a misdemeanor, no accident, no injuries, no kids, nobody goes to jail for that. You would have to walk into court and literally, pardon me, but take a dump on the floor in front of the judge in order to get sentenced to jail for this case.
And even then, you want to get sentenced to jail. The judge might get pissed and hold you in contempt, but he's not going to sentence you to jail for DUI.
But now these 2 bribery counts are 2 felonies. So now he's looking at 10 years in prison.
Before you go on to the bribery, remember the show we did where alcohol, in any cases where it involves alcohol, has other collateral issues. If it appears that this guy was intoxicated, it appears that he was. It appears that his bad judgment caused him, if he did, to try and bribe 2 officers. And now look, he's got bribery charges hanging over his head because he wasn't thinking clearly and he thought somehow he was going to bribe these cops to drop the DUI, if that's what he did. But Michael and I are going to go through that now. So quickly, Mike.
We got to do it quick. So with bribery, I'll read you the jury instruction. It's very, very quick. Bribery of a public servant. To prove the crime of bribery of a public servant, the state must prove the following 5 elements beyond a reasonable doubt. 1, X person was a public servant. 2, the defendant knew that public servant was a public servant. Well, these 2 are going to be real easy in this case because both of them are uniformed police officers. 3, defendant knowingly and intentionally gave, offered, or promised that public servant a pecuniary or other benefit. So now they got to prove that this guy actually offered 2 $100 bills to the first cop and a wad of 1s and 5s to the second cop. Again, if there's body worn, it's going to be relatively easy to prove, whereas if there's no body worn, it's going to be more difficult. 4, the defendant's gift, offer, or promise was made with the intent or purpose to influence the public servant in the performance of any act or omission that the defendant believed to be within the discretion of the officer in the performance of their public duty. And 5, the pecuniary or other benefit was not authorized by law.
So the issue here boils down to number 4. And here's what some of the cases say. And that's why it was very important to quote did he in fact say he's offering the money to make it go away? If they have a body-worn camera where he offered the money to make it go away, slam dunk for the state, because he clearly was giving him money to make this case go away. If he didn't give the meaning, if he didn't say those words, then there's a chance that you can make an argument that he was just impaired and he thought they were the valet drivers. And that's how drunk he was. So at least it'll get you out of the bribery charge. And here's what the case law says. Unless it's clear that there was nothing being asked in exchange for the case to be dropped and the situation itself doesn't call for that, it goes to the trier of fact. So it'll go to a jury. This will be very hard to get it dismissed. And let me give you the quick example of the case so you get an understanding of what they're talking about. One of the cases out of I believe it was the third DCA, where there was a guy being investigated. He had a company, was being investigated for complaints sent to the Better Business Bureau. It was a laundry list of people that had made complaints. And he called the investigator and asked the investigator to send him a copy of the list of people who had made complaints. When it went to motion to dismiss, his argument was, I asked for the list in preparation for restitution. I never asked for the list in order to get them to drop it. And if you look at that case, what possible benefit could he get from asking for the list? So the third said that the lower court did not dismiss it, and the third said, no, you should have dismissed it, because here there was just no relevance to any type of benefit for asking for the list. So that would be an example where you get it dismissed. But aside from that, it goes to the jury. And I think in this case, this would go to the jury and let the jury decide, what did he mean by take it?
Well, the point is, both of these guys are in some hot water. And I would say, just in wrapping up real quick, one of the things Ed mentioned, and I happen to agree, if we were consulted by the individual in the first case, the Metro-Dade police officer with the cocaine and the firearm, one of the things that we would do is, if we were contacted proximate enough to the incident, we would send him to LabCorp for a blood test immediately, because we'd want to know whether or not there was cocaine in his system. If there was no cocaine in his system and it was within the look back window reflective of that blood test, that would be very good evidence for us. And then we would also advise him that we want to go 6-8 weeks out, because that's about the reflection time for a hair follicle test. You have to wait about 6 or 8 weeks after the date of ingestion for the hair follicle test to be valid. That's the look back window for that. So that's one suggestion we might do for him in order to try and assist him in that, because he's going to have a problem at work. And so even if that's not helpful in the criminal case, it may be helpful with his union rep or whatever private lawyer he has, if he has counsel, or just himself during his internal investigation. And with regards to this second individual, he's a train wreck. So one of the things we're going to want to do with a guy like this, maybe not in a first DUI, but if it were a second within 5 or a third within 10, if it were an accident with injuries, if it were a DUI case where jail or prison were on the table just because of the nature of the offense itself, and again, a first simple plain Jane DUI doesn't come with that, we would probably talk to him about going in immediately into a residential rehab, and serving a period of time in residential rehab where we could build a track record and show some sort of at least amenable insight and willingness to better oneself, which gives us something to argue to a judge in mitigation of a sentence. So it's not always, obviously our first tier is to find a factual, legal, procedural, or substantive mechanism to attack or beat the case. Our second tier is to find a loophole or a technicality that we can use. But our third tier is mitigation. It's always our third tier, and we never let that go, because you could have the best case in the world and lose, and you could have the worst dog with fleas you ever saw, kind of like this DUI case, and still win. So what happens if they lose the body worn? What happens if the machine that he blew into when Ed and I pulled those maintenance records, what if it was taken offline the next day and had to be serviced? Who knows? Well, anything's possible, and diligence is required. I hope that we've given you a little bit of insight into how we assess the probable cause determination by police. And the next step, again, we can't do here because it would require necessarily a discussion with the accused, and then some possibly some further discussion because there may be defense witnesses that we may need to interview or bring in. For example, again, let's go back to the cop. Let's say they have a housekeeper who wasn't present. But let's say the housekeeper is aware that they have a teenage kid that always has friends over, and the housekeeper has caught them doing drugs in the past. These types of things could be very persuasive in terms of defense evidence to attack a circumstantial, non-actual possession case, a constructive possession case. So, food for thought. Anyhow, I hope that we were able to do that satisfactorily and give you guys some good insight and maybe even a little entertainment and some good knowledge. Remember, you do not need to take those FSTs. You can, but you don't have to. With that said, thank you guys for paying attention to episode 51. And we look forward to seeing you next week on the 17th for episode 52. And on the 24th, we have a special guest coming for what I hope to be a really fabulous, scintillating episode that I won't tease anymore until then. That said, thank you guys very much. Thank you to our producers over at Miami's Community Newspapers, and we apologize for running over by about 5 minutes. We'll see you all next week. Thank you, Martinez.
Thank you, brother.